now live on YouTube, and I'd like to welcome you to another edition of our Justice in Pieces guest speaker series. Today's guest is a criminal defense lawyer from Pashang Law. So thank you very much to my friend Sia Pashang for joining us. So
Good
Sia,
evening. Thank you.
perhaps you can do a quick introduction about your practice, and I know you want to talk to us about informed guilty pleas. So perhaps maybe a quick introduction, and then we can get started.
Yes, sure. Thank you. Good evening, and thanks for having me, Mr. Rodriguez. I'm really happy to be here. I know this is a very successful series that you operate, so I'm very happy to be a part of it. So, right, I'm a criminal defense lawyer practicing out of Toronto, Ontario. However, the reach of my practice spans all of the GTA, from east to west, Hamilton to Belleville, and everything else in between. I essentially defend and cover all areas of criminal defense, from simple assaults, theft, to some more major serious violent offenses as well. I've been practicing for about 5 years now. I started with a large criminal defense firm in Toronto, and after a few years, I took the leap and decided to start my own shop, started my own business. Professional corporation. So now I have, for about 2 years now, just under 2 years, I've been operating out of Pashang Law, and as a sole practitioner, essentially, in the chambers. I have an office among other criminal defense lawyers, and my practice has been sort of continuing from there. And of course, now we've reached the pandemic and then various different, unknowns that we have to all sort of put our minds to, but it's been going well, and I'm really happy to have taken that leap. Okay, so putting that aside, the topic of discussion that I want to sort of go over today is guilty pleas. Classic scenario of a client walks into your office and says, I've been charged with this offense, and I just want to get it over with. I want to plead guilty. And so what does that entail? What goes into that? And what does the client need to know in order to plead guilty? And of course, I'll try to, somehow weave this into what your paralegal program and what, it would, something like this, a client walking in and wanting to plead guilty would mean to not only lawyers, but also paralegals. And I'll go over some, introductory aspects about what it entails to plead guilty pursuant to the criminal code, as well as some ethical rules of professional conduct that both lawyers and paralegals must adhere to, as provided by the Law Society, mandated by the Law Society, and perhaps further some ethical dilemmas as to when you, what if your client is in fact innocent but still wants to plead guilt? What do you do? So first of all, guilty pleas are a staple of criminal law in Canada. In fact, the majority of cases resolving in this fashion, despite what we see on TV and about trials and the complexities of trials and jury trials and whatnot, or even the news media here in our city about popular or sort of newsworthy cases that are in the process of trial. The majority of these criminal cases, in fact, significant amount, end up resolving, and resolution can mean various things, but guilty plea is in fact one of them. So, resolutions are significant to both a fair and efficient operation of the criminal justice system, and the individual who pleads guilty is a function of that. Guilty pleas can be a recognized mechanism by which to accomplish, inexpensive resolution of a large percentage of the charges before the courts, to unclog the court system and ensure that it's smoothly operating in light of the many charges within our courts. So I think more than ever, an effective negotiation with the prosecution as a defense lawyer has the potential to secure an excellent result for a client. And I think that's something that all defense lawyers definitely keep in mind. Now, from the outset, when a client is, charged and comes to your office, with that, I've been charged. I want to get this over with sort of mentality. Often in the charge screening form as part of the disclosure, you'll see that the Crown will have a position already outlined on the document that really lays out on a guilty plea what their position would be, and perhaps beyond that on the finding of guilt, if the individual is found guilty, what their sentencing position would be. So here that we know that the Crown is a critical decision maker in the result ultimately that will be obtained by a plea bargain. And so the result that a defense will want to achieve will be a sentence that falls, of course, on the very lower end part of the sort of appropriate range of any sentence. And it would be a sentence that could, not typically be obtained by way of a traditional, going to trial and being found guilty by a judge or jury, and, a contested sentencing hearing. So often the focus of the work to be performed by the defense, the lawyer, for the client in such a case will be on securing, an agreement with the Crown that may perhaps lead to a joint submission that benefits and really secures a sentence that will be satisfactory to the judge. But of course, once that position is secured, and in light of the Crown's important role, of course, the judicial approval will have to follow. Now, in view of the large number of criminal cases that are disposed of by way of guilty pleas, cases concluding in joint submissions will, inevitably represent a meaningful proportion of any defense lawyer's work. So there's something to be said as practitioners out there about fostering, lasting, positive relationships with those in the Crown's office. Of course, maintaining the adversarial nature of our job, but also being able to negotiate and be in a position to find reasonable grounds with it, the other side, the Crown's office, and of course. Proceedings and such as judicial pretrials with judges throughout this process before the resolution will assist as well, as judges will provide input if you have an issue with the Crown's laying of multiple charges and dispute the fact that so many charges should be laid, for example. You can have judicial input and hopefully dispose of certain things and sort of technical or complicated issues from a judicial standpoint. Now, a plea involves both a substantive and procedural element. Substantively, the client, has to admit to the elements of the offense that's being committed, which then will render a finding of guilt. But in doing so, it's important to note that the client is also waiving his or her constitutional right to be presumed innocent and to have a fair and public trial. Now, I'm sure you guys in the program have at length, studied the Charter, Canadian Charter of Rights, but the focus of what I just said, is outlined in Section 11, sub D of the Canadian Charter of Rights, which states that any person charged with an offence has the right to be presumed innocent until proven guilty, according to law, in a fair and public hearing by an independent and impartial tribunal. And then, of course, beyond that, at which time the Crown would have to prove each element of the charges that are being pled. Not pled, but of every element of the charge or offense is beyond a reasonable doubt, and this is a common law standard. So by pleading guilty, the accused is giving that up, and that's quite significant. Now, so of course, the accused more simply is relinquishing their right to go to a trial in exchange for a benefit, essentially. And there's a list of why and reasons as to what go into a resolution or a plea of guilt. Some examples could include reduction in the charge, withdrawal of some charges that are laid in the information or indictment, a promise not to proceed on other charges, perhaps by a Crown, recommendation or promise as to the type of sentence to be expected, whether it's a fine or probation, imprisonment, etc. So again, the mechanism of a joint position or submission can sort of tailor that and narrow that down. And for example, a Crown's election to proceed summarily on a resolution or guilty plea versus by indictment if the offense if the Crown has the option, if it then goes to trial. So, but other factors, and not so positive ones, that go into sometimes why individuals plead guilty is sometimes there's an added cost of going to trial, and the incurring lawyer fees, that could be problematic and perhaps in many ways pressure individuals or accused to resolve or plead guilty, as opposed to going to trial and testing the evidence against them. So the accused will have to attend multitude of preliminary court dates, bail hearings, set dates, pre-trials, and so forth. So that can be a mounting expense, and perhaps convince an individual to plea instead of go to trial. So those are all factors that we have to sort of recognize. Now, just sort of the professional conduct aspect of this presentation, just for you paralegals, in the paralegal rules of conduct section, rule 4 in the advocacy section, 4.01, it states title of paralegal as advocate. So number 4 states, without restricting the generality of sub-rule 1, the paralegal shall raise fearlessly every issue, advance every argument, and ask every question, however distasteful, that the paralegal thinks will help the client's case. B, endeavor on the client's behalf to obtain the benefit of every remedy and defense authorized by law. C, never waive or abandon the client's legal rights, for example, an available defense under a statute of limitations without the client's informed consent. And here's, I stress that, highlight that, the informed consent. And D, avoid and discourage the client from resorting to frivolous and vexatious objections, or from attempts to gain advantage from mistakes or oversights not going to the merits, or from the tactics designed to merely delay or harass the other side. So, and the title of agreement on a guilty plea for paralegals in section 8, before a charge is laid out or at any time after a charge is laid, a paralegal acting for an accused or potential accused may discuss with the prosecutor the possible disposition of the case, unless the client instructs otherwise. And I'm going to get to why client instruction is very important. And number 9, a paralegal on behalf of his or her client may enter into an agreement with the prosecutor about a guilty plea if, following investigation, the paralegal advises the client about the prospects for an acquittal or a finding of guilt, and etc. So there are various implications and consequences of a guilty plea that are laid out by the Law Society for both paralegals and lawyers. And another section states the client is prepared to voluntarily to admit the necessary factual and mental elements of the offense charged, and the client voluntarily instructs the paralegal to enter into an agreement as to the plea. And of course, lawyers have their own section in their rules of professional conduct, section 5.1, 1 to 7. And very similar, but sort of, there are different wording there, but similar sort of voluntary nature of a guilty plea is stressed here as well. So what goes into the conditions for accepting a guilty plea? Now, we'll go to the criminal code, and you can write this down if you don't know it already, but section 606 sub 1.1 of the criminal code essentially states that the court may accept a guilty plea only if it's satisfied that the accused, and then they give a following list of what these acceptances are. A, the accused is making a plea voluntarily, and B, understands and that the plea is an admission of the essential elements of the offense, that the nature and consequences of the plea, and that the court is not bound by any agreement made between the accused and the prosecutor. So this essentially says that, and all lawyers have to go over what's called the plea comprehension with their clients before any plea is deemed informed. And this is done typically in advance of the court appearance itself. Diligent lawyers should absolutely go over this plea comprehension inquiry with their clients. But also what will often happen, I think this is fantastic, that judges will conduct their own inquiry of the very sections I just referred to in 606 and ensure that this plea is in fact informed. And where some judges will put counsel or paralegals perhaps on the spot is they'll ask you in advance of conducting this plea whether you have in fact gone over this with your client and whether you're satisfied that the plea is informed, and you'll of course have to say yes. And at any point, if any of these prongs of section 606 are not satisfactory to a judge or a court, then of course the plea cannot be entered. So I think I stress that it's very important. So what does, for example, voluntary even mean? It's a conscious decision of the accused to plead guilty for reasons that the accused considers appropriate. Okay, so if the accused is pressured to plead guilty, then the plea is not satisfactory. Okay, so what is an unequivocal plea? This mandates that it not be made in circumstances that would suggest the plea was confusing, unintended, or that the accused did not intend to admit the essential elements of the offense, which they would have to do in order for it to be informed. Okay, so it can't be qualified or modified or conditional on anything else for it to be deemed approved. And so the accused must understand the nature of the charges, the legal effects of the plea, and of course the consequences. And so in cases where the accused is in fact represented, the client is represented by counsel or paralegal, it's important consideration that that the lawyers have to tell their clients, or paralegal have to tell their clients, that despite the position of the parties, from the defense position or the Crown position, or the fact that it might even be a joint submission prepared from both sides, that of course the judge has the final say, the final determination as to sort of consequences and sentence. And that's very important as well. Okay, so that's sort of a very brief nutshell that kind of encapsulates section 606. And further, so what does it mean for a plea to be informed? So all criminal lawyers know that a guilty plea isn't valid if the client doesn't understand those consequences and what we discussed in the criminal code. So very briefly, I'll just talk about a case where a plea was deemed uninformed. It's an Ontario case, Court of Appeal case, RV Quick, 2016 ONCA 95 is the citation. So just briefly, the facts of that case were that the accused, or the appellant, was a truck driver. He was charged with dangerous driving, but he had 2 previous driving offenses on his record. And with this added third driving charge, this dangerous driving, he was possibly facing indefinite suspension of his license and his driving capabilities. He ended up pleading guilty, and later he indicated that his lawyer, so on appeal, he indicated that his trial lawyer told him that, his plea lawyer told him that his license would only be suspended 1 year. Again, just note that he was a truck driver and dependent on driving as a means for his livelihood. So he took the deal because he thought that, hey, I'm getting this 1 year deal. This is the best outcome, given that I want to go back to driving after. But little did he know, under the Highway Traffic Act, HTA, his license was in fact suspended indefinitely, and that was triggered by the dangerous driving charge pursuant to the criminal code. So the Ontario Court of Appeal, so this fellow's in a bind. So the Ontario Court of Appeal created, in this case, created a subjective test stating that a plea is uninformed if it is, quote, realistic likelihood that the client or the accused, if otherwise informed of an unforeseen consequence, would not have pleaded guilty and instead would have gone to trial. So that's sort of the test. And the court noted that the consequences of a plea that the client must understand are largely limited to those that are legally relevant. And so what does legally relevant mean? At the least, the court found that relevant means that they must include penalties that are imposed by the state, which captures, non-criminal consequences and penalties that have effect on criminal code offenses. So these include sort of collateral consequences such as immigration consequences for the accused person in light of this plea, or driver's license suspensions, which was the case in this one here, which again are state mandated and could have consequences. There are, however, limitations on this rule. And the court noted that an informed plea that we just reviewed does not mean that the client must understand every single collateral consequence of his or her plea, even if it's legally relevant, and if they are, and that would be the case if those consequences are too remote or inconsequential to really the validity of the plea overall. The court also noted that specific facts and the importance of them to each accused are important. For example, if entering a plea means you're unaware of an indefinite driving suspension, such as in this case, this might mean it's uninformed on those facts alone. So, however, if that same person was not allowed to drive anyway, say due to health reasons or other issues, notwithstanding this plea, then that may not really get it over that threshold, okay? So essentially what the court was saying is that we have to look at cases on a fact-specific inquiry, sort of case-by-case, factual-based determination as to the legal relevance and significance of some of these collateral consequences to each and every accused. So essentially the court is making a subjective test, and in this case, it was the livelihood and the main source of income for driving for this individual that really came to be the heart of why this was so important, and this uninformed sort of plea was so significant. So that he would not have pleaded guilty, and would have sought a trial had he known that his conviction for dangerous driving would have suspended his license indefinitely. And of course, the prejudice of an uninformed plea lies in giving up your right to a trial. So the takeaways from that case, the Court of Appeal case, are that we know that the plea must be informed on some collateral consequence beyond those just in the criminal code. So that's significant. And then accused who is unaware of Highway Traffic Act or immigration refugee consequences has a strong claim for uninformed nature of a plea. But secondly, we are still unclear about the meaning of what the court states at the time as to what something that's too remote or insignificant or similar to the consequences actually means. So in order to deem the plea invalid, where do we draw the line as to sort of what consequences collaterally can be had? So the court stated that we know that relevant consequences could in fact include ones that can be imposed by the state. So driving prohibition or immigration consequences are state-driven consequences. But what about the consequences that arise from another entity or body? These are questions that sort of arise from this case. If the test is in fact subjective, very case-by-case, individual by individual analysis, what if this most severe consequences for an individual or accused arises from another unanticipated source, such as an automatic dismissal from his or her employment, which is not necessarily a state mandated, but it could be within the sort of parameters of an employer. So what if firing from an employer under a term of his or her contract states that if you were convicted of such and such under the criminal code, then you could be dismissed. That subjectively really can affect a certain individual, but could it render a plea invalid or uninformed? So these are sort of some of the questions and concerns that would arise. And the case of very recent case of R.V. Wong, it's a Supreme Court case, recently established that a guilty plea may be withdrawn if the accused shows that, one, he or she was not aware of a legally relevant collateral consequence, which includes the immigration, driving suspensions and whatnot. And two, there is a reasonable possibility that he or she would have proceeded differently if properly informed of that consequence. Okay. So again, this case, I highly recommend many of you to go and check it out. It really goes into the informed plea discussion and what it means in a criminal setting. So it clarifies the approach to determining prejudice in the context of an uninformed plea and concludes that the approach is a subjective one. So it confirms that. While an objective basis may be used to determine if the plea was uninformed, the approach to determining prejudice and thus a miscarriage of justice warranting removal is subject. And in this case, I say removal because Mr. Wong was facing deportation. Okay. Right. So moving on to another section that often will affect counsel, lawyers, paralegals, guilty pleas and ineffective assistance of counsel. And so, obviously certain things that we need as representatives need to be aware of in order to avoid any issues or problems with the law society, but of course ensuring that our clients receive the optimal representation. So allegations of ineffective assistance of counsel may arise when the client seeks to withdraw a guilty plea, okay, on appeal perhaps. So efforts to set aside guilty pleas are often based on several types of claims by clients. First one, the lawyer didn't advise me as to the consequences of the plea, okay? Or the lawyer failed to advise of the effect of a plea, which involves admissions to the elements of the offense, where the client, disputed some elements or facts of such offenses. Another one could be client claims that they lacked the cognitive capacity to understand the guilty pleas. Okay, so as such, the plea itself was not informed or even voluntary. Or another one is that the lawyer's advice to the plea was not adequate and thus incompetent because the client actually had a viable or effective defense. So these are all certain things that we as counsel must be mindful of when we're sitting down with our clients, whether it's in the office or in a jail cell. And going over some of the options and if a guilty plea is in fact something that's on the table. Just a couple of cases. One of them, in the case of R.V. Johnston, Ontario Court of Appeal decision 2009, the client claimed that his counsel failed to advise him of the possibility that he could face additional jail time as a result of pleading guilty. So he's saying, the client's saying that lawyer didn't tell me that was a possibility, that I could face further jail. The court accepted that while the lawyer's practice and file management efforts were lacking in, subpar, that the lawyer's communication with the client were not, also that the communication with the client were not timely or meaningful. However, the court ruled that there were in fact documentations found with respect to advice given to the client, which confirmed that the client had been told about the risks of further jail time. So the lesson here is really make sure you docket and you note things down and you make notes about the discussion that you have, but also ensure that you're prudent, concise, and very forthright and detail-oriented with your clients about the risks, pros and cons and consequences of pleading guilty to the extent that they're known, and so that a client may possibly face in any outcome. So this are tenets of an informed plea, okay? So while the court was critical of the lawyer who was who has very little documentation in his file concerning the discussions that he had with this client, and they amounted just brief meetings and whatnot. But nonetheless, the appeal was dismissed. But I think this is a learning lesson that we need to, as counsel, be very open and have forthright discussions about some of these risks. And if we don't understand or know, because our area of practice, for example, doesn't fall under immigration law, then we need to be sure that we inform the client that they can and they should seek that particular legal advice for that area of law that is a collateral consequence elsewhere. Seek the advice of a refugee immigration lawyer if there's any likelihood that knowing that they're not Canadian citizens, perhaps, that it could affect their ability to remain in Canada. Because I, for one, am not an immigration refugee lawyer, and I will not be able to provide that legal advice. And as such, I need to ensure that my client's plea is informed that he doesn't have very costly consequences upon a plea of guilt in my realm, which is criminal law, but then face deportation, perhaps, for something that he or she may not have known otherwise, but should have. And often, I will make this known in court that I have given my client that advice to go seek I've given my client that option to go and seek advice of a criminal or a refugee or immigration lawyer. And often judges ensure that that has been accomplished as well. And there's only so much you can do, right? Moving on, often, sorry, I'll go through another one. It's a case of R.V. Bayless, 2015 Ontario Court of Appeal. This case was, the ineffective assistance of counsel was also dismissed on cognitive understanding. So what is the meaning of cognitive understanding? So in that case, the client claimed that he suffered from cognitive and emotional problems that deemed him incapable of understanding the consequences of his guilty plea, as throughout the discussions with the lawyer. He claimed that his lawyer was incompetent for not adducing evidence of the client's condition before sentencing, but the court proceeded to use a test for such cognitive or emotional factors, and that those included that the accused may suffer from a significant mental disorder, yet still be capable of entering valid pleas of guilt. So that's possible. That in order to render pleas to be ineffective, the disorder must be such as to render the accused incapable of making a conscious choice as to his or her plea. So it's not enough, the court said, that the mental disorder impaired the accused's decision-making ability, or even that it rendered the decision as irrational. The Court of Appeal ruled that there is nothing in the record to suggest that the appellant, the client, suffered from the kind of mental disorder that would deem him incapable of entering a plea. So it's important to note that ineffective assistance of counsel will be a valid appeal, and a guilty plea can be set aside if the lawyer had advised the appellant to plead guilty without any identifying or investigating defenses, and failing to provide meaningful advice on the likelihood of success at trial. This possibly qualifies as an uninformed plea. So again, lawyers and paralegals and advocates must be careful and very mindful of some of these kind of factors and variables here. So really, what about the dilemma of, sorry, let me just see if there's any questions here. I thought I saw something. Okay. So pleading guilty when innocent. That we sometimes hear about that. What are the ramifications of that? What if you know that your client, tells you they're innocent, but they're still pleading guilty? This is a tough one, but there's often pressure, and it speaks to sort of an institutional aspect and the way our system is set up, and some of the inadequacies of our system. But the pressure to plead guilty when innocent is probably even greater with minor offenses than you would think major ones, because the process costs, the costs of the process far outweigh the costs of going to trial. So it's less likely that the truth behind these low stakes pleas would come to anyone's attention, and therefore we're less likely to know the extent to which they take place. And they do happen, I can tell you. Some have suggested that innocent accused might be even more averse to risk, and therefore more prone to plead guilty when presented with an enticing offer. So you often find many accused persons who, right at first instance, when they address bail and get detained, and bail court is a trier of risk. it's not looking at, it's not a trial court. But many individuals who are detained at bail or denied bail, sorry, opt to end the proceedings if they can right away, and plead guilty if it means that they will get released, given they've faced the extent of their sentence for that plea, and that's unfortunate, but it happens quite a lot. And I mean, we have to ask ourselves, how many people are going to say no to that, right? If they're in custody. So again, I would say it happens hundreds of times a day. So this highlights the importance of accused persons, receiving correct advice about the prospects of an acquittal, for example, and to minimize the incidence of a false, guilty pleas. We must, at the minimum, strive to ensure that the innocent accused are not, waiving their right to a trial needlessly based on, ill-considered or uninformed legal advice. So as lawyers, as representatives, we need to ensure that we do that. And it's tough because in Canada, the rules of professional conduct don't really provide clear answers to this dilemma, right? There is, of course, the general ethical rule that prevents counsel from misleading the court, okay? And I'll read you a section here from the rules of professional conduct in the lawyer section. When acting as an advocate, a lawyer shall not, section A, it's 5.1 and 2, but section sub B, the lawyer shall not knowingly assist or permit the client to do anything that the lawyer considers to be dishonest or dishonorable. C, the shall not appear before a judicial officer when the lawyer, the lawyer's associates, or the clients have a business or personal relationship with the officer that gives rise to or might reasonably appear to give rise to pressure, influence, or inducement affecting the impartiality of the officer, unless all parties consent and it is in the interest of justice. And D, shall not endeavor or allow anyone else to endeavor, directly or indirectly, to influence the decision or action of a tribunal or any of its officials, or in any case or matter by any means that are means that other than open persuasion as an advocate. So I feel personally that there's an absence of any explicit guidance from the rules in the profession, and that's a bit troubling, given that a large majority of cases in Canada, as I said, are resolved by way of a guilty plea or resolution. This is an ethical dilemma that most, if not all, advocates, defense counsel, they're going to face it at any given time in their career, and that it's only reasonable to assume that many innocent accused do in fact plead guilty to the to avoid the risks, as I kind of referred to, or potentially increased period of imprisonment, or to avoid the barbaric, conditions of pretrial detention, which is a whole other subject area that I won't get into. But especially in the, in a time of pandemic with COVID-19, where, depopulating the prisons is and should be our number one kind of rule, and that, of course, will sort of fuel more as to the reasons why the accused might want to get out of jail quick, if it means even pleading guilty for something that they haven't done. And so in Ontario, there's currently a crisis in the bail system, with more accused having to, wait longer for bail hearings and higher remand rates than ever before. Of course, the pandemic, they have attempted, Crown attorneys have been very good in trying to sort of depopulate for more minor offenses, but we have a long way to go. However, instances like this are only going to, increase the number of innocent accused pleading guilty. And we have to be mindful of that. So I know I didn't give a really, concrete answer as to sort of how to deal with that particular dilemma, but that's because, institutionally, it's still a little diluted. But what I wanted to talk about was what you should do when, dealing with a resolution or guilty plea with a client. Always get things in writing. That should be a go-to practice for everyone. If your client agrees and is willing to admit to the facts of of the case, and ensure that indicates that it's voluntary, no one's pressuring them, that they understand that they're giving up their right to a trial, and that despite the positions of the parties, the judge gives the final say. So those are the features of Section 606 of the plea comprehension. Make sure you get that in writing from your client. And of course, if you're able to put the immigration consequences or any other collateral consequences in the document itself and have it signed. So what I always do is I have an instruction to counsel, sort of a generic document that says, I, X client, hereby instruct Sia Pashang that I wish to resolve and enter a plea of guilt, in the Ontario Court of Justice, for example, on this outstanding charge, and list the charge or charges. And I often go even further and I say, I understand the Crown's, if you have a Crown's position in advance, and it's relayed to you, I understand the Crown is seeking this much following punishment or following the plea of guilt. So this sentence, and my defense lawyer is requesting or seeking this sentence. But I also understand that despite these positions, the judge has the final say. But at least it's laid out, so there's no surprises. There's no, oh, you didn't tell me what the counts were, or I was a little bit fuzzy on that. So you safeguard yourself as well, but ensure that everything's transparent. Transparency is very important. So the positions of if at all possible, the positions of the parties are listed in this document as well. And I also have it state that I could go to trial, but I'm choosing not to. The Crown could prove it. Otherwise, we'll have to prove the case beyond a reasonable doubt in the allegations, but I'm choosing to waive that right. And I also say that, and I alluded to it earlier, that my counsel has not provided me with any legal advice as to the impact of a finding of guilt on other collateral matters, such as immigration, family law implications, tax, future employment, or any legal issues that may arise from this criminal code plea. Okay, and of course that I would have it that my lawyer advised that I should go elsewhere and seek advice if it impacts me. Okay, so by pleading guilty, I admit to the essential elements of this, of these charges, of these counts, and to the facts as read out. Often there's a agreed statement of facts. That could be the case. Depends how complicated a charge or charges are, and of course I'll have my client consent and agree to that as well. Okay, and yeah, I think have the document signed by your client, dated, and of course keep it in your records. Okay, so I think that will go a long way with some of the future, litigation that you do not want, such as the ineffective assistance of counsel or your client really falling under and falling under the bus and getting in trouble. You don't want that. You want this to be a safe and effective resolution for your client and for him or her to get the best possible outcome. Okay, so unless you have any subject to any questions, those are my comments on guilty pleas. In court, we would say subject to any questions. Those are my submissions, but it won't apply.
Thank you so much for that.
My pleasure.
Yeah, so just a couple things maybe related to some of those points there. What, in terms of, you were mentioning putting in let's say immigration consequences or potential, let's say you were representing a paralegal, for example, and they could be disciplined by the Law Society for a criminal conviction, right? Is it better, like you said, to just list these are potential areas and you should consult with specific people and seek independent legal advice or something along those lines? Or should you attempt to help get that information for them and put that in there? What do you think is sort of the approach? Because obviously you can't necessarily do it if, let's say, you're not a family lawyer, so you wouldn't know the impact on custody or support or something like that. But is it better to mention that and say to get assistance elsewhere, or is it better to try to find out the answers elsewhere and then mention that in from like in the report or something like that?
Right. So I personally, I would ask them to go and seek it themselves and get a report, get the legal advice in writing, so that it helps in court in the criminal proceedings to provide a document or some sort of obvious implication of family court order or immigration consequences on the document or paper as an exhibit in court, so that the judge also reads it and sees it. So for that reason, I would be hesitant to to merely speak to say an immigration or refugee lawyer, hopefully understand from what they told me on the phone what I believe to be the consequences, and then put that into my own submissions. That would still be, I think, ineffective, in my opinion. I think you should, as an advocate, have the client seek it independently with independent legal advice, and do that separately. And there are, and to be fair, there are lawyers who we build relationships with, because this is not something that is uncommon. So I think I can guide them to a referral, but I think getting that advice on their own so that they truly understand the implications of those consequences themselves, so that they will then give the informed plea, is the most important, as opposed to me kind of watering it down and maybe getting it wrong, because again, I'm not giving that advice. So to answer your question, I think independent legal advice would be the way to go. Now, it doesn't preclude me from my own kind of sense of sort of grasping some knowledge in other areas of law, to call an immigration lawyer or family law lawyer to get a sense of certain implications or consequences. But when it comes to a guilty plea where it can affect the livelihood, I've mentioned livelihood before, of an individual, that's a risk you don't want to take, but also you don't want to get it wrong.
Now, sometimes a lot of these things happen kind of maybe spur of the moment. You might have a Crown pretrial or a judicial pretrial, and you get a position, and maybe they want to speak to it later that day in court, or virtual court, I guess now. Is that something maybe you want to hold off on, maybe adjourning a few weeks so you can get something in writing? Or are you okay relying on the judge doing a plea inquiry on the record, or should you do both? Have something in writing, and then still nonetheless get the judge to ask, is this an informed plea of your client? What would you recommend?
Right. So I think I would do both, combination of both. Sometimes it would be ideal if a client is going to resolve plea guilty, it would be ideal to adjourn it a few weeks. By that, by adjourn, we mean remand it, put it over a couple of weeks, to then do the plea at a later date, so that in the interim you can get all the information and gather all the documents that you need, have the client seek the legal advice from an immigration or family lawyer. But sometimes we don't have that privilege or advantage of time, because your client might be in custody, and the position is almost time served, or that he be released on a joint submission in a week, as opposed to 2 weeks that it takes to get those documents. So it becomes tricky and difficult. And again, that's another dilemma that many have to deal with. But I think at that point, ensuring that a judge satisfies, the court, and asks the client themselves about whether they understand and know the consequences, is important. But it's tough when your client's in custody. But ideally, I would put it aside so that we can get all the different exhibits and documents that we need to make sure that it's informed and the consequences are not severe.
Now, another issue especially with people in custody, let's say there is a video or surveillance video or some piece of disclosure that might potentially raise a defense, and the Crown has been, or the police, or somehow it's been delayed in getting to, and they might have a position of time served or something, and your client wants to jump on that, but there may have been a potential defense to raise if you saw that disclosure. What do you do ethically if no, and again, it's through no fault of your own, because you're requesting the information, but you don't know when it's going to come, and your client's telling you, hey, I just need to get out of here. What's the point in waiting 3 months for this disclosure if we're going to resolve it anyways, and I'm going to end up spending 3 extra months in custody for no reason?
Right. So I think in one of the cases, I briefly glossed over it, but ensuring that the case, you present everything that you know to your client is fundamental here, right? So if again you don't have this piece of video disclosure that will make or break this case, and given what you know about the facts of this case, you are quite certain that upon review of this video that it will in fact deem your client innocent, or ID might be an issue. You have to relay that to your client, and I think your client has to know what to anticipate if you do get that piece of disclosure. But if they don't want to wait, and they are still instructing you that they want to plead guilty and this is an informed plea and that they are admitting to the facts, I think you've satisfied your obligation to proceed on that basis, as long as, again, the elements of the plea inquiry in section 606 are met and you're satisfied. And of course, a judge is satisfied in court when they present it, but your client has to know, and you have to be very forthright and candid with your client about what may be further defenses to be, to proceed, and that may exonerate them down the road, but it's just not available to you. And of course, I would push and try to get that piece of disclosure or whatever it is, evidence from the Crown as soon as possible. But as long as your client knows what the consequences are, there's only so much you can do, because it's out of your control. It's a defense counsel as well that you can't get that piece of disclosure in a timely fashion. But again, those are some of the unfortunate consequences of being in this sort of dilemma of pleading guilty when time is of the essence.
And then on that point, if they do say something like, well, I didn't really do it, but I just want to get out of here, kind of, you were alluding to this earlier, what can you do ethically if they're insisted on doing? Is it something that you can't assist them with a guilty plea if they're not willing to admit the elements of the offense, or what should you do if you're stuck in that situation?
Right. If you're not, as counsel, not satisfied that it's an informed plea and that all the components of a plea inquiry are not met, I would at that point excuse myself and get off the record. Unfortunately, I won't be ethically in a position to as their advocate to proceed on a guilty plea, knowing that, and again, this is confidential information. It's privileged, but and it'll stay that way. I can't necessarily go to a judge and say, in fact, I know he didn't do it, but I'm going forward, or vice versa, or lay out some of the discussions. But I will simply ask myself to be removed from the record, and that client can then proceed and find other counsel and hopefully figure out how to go about it in a different way. But my obligation ethically is to remove myself.
Now, maybe a more general question here from one of the students about, well, what are the challenges, I think, in being in criminal defense, and some of the most rewarding aspects, especially when you're talking about dealing with situations where there may be having to resolve a matter and try to get the best position, I guess, and advocate the best for your client. What do you see as a challenge for that, and what do you see as a reward in this field?
Yeah, so I would say a reward is, just to put it simply, and I think this is, you hear this over and over again, but you are dealing with humans and real issues in their lives. It's often their livelihoods. The presumption of innocence is such an important feature of our justice system and democracy, and you're partly responsible to ensure that they have that fair shake. Now, getting good results for your clients, seeing them go through the judicial system and getting the best results is the most rewarding part of being a defense lawyer. And often your clients their backs are against the wall. Many, including society at large, are sort of have this view of those who are charged. They deem them as criminals, and you're often, as counsel, the only person who's by their side. So you want to make sure that you give them that opportunity and that build that trust. So that's quite rewarding, knowing that there's so much on the line. However, there are challenges. It can become complicated. Often clients can be frustrated, and so it might be difficult to navigate the system and get the best results for them in a timely manner. But and also dealing with sort of the Goliath that is the justice system, that you feel like so much is against you as a defense lawyer that you have to navigate through and weave through and ensure that with the limited resources that you have, you obtain the best results. That's not always easy, especially as a sole practitioner. I think not having resources is probably one of the biggest challenges for me. But again, that's the nature of the job, and I think it takes a certain individual to do this type of work. But it's so rewarding when you get results and have clients thank you for it. And I think that sort of outweighs any negative or feature that may not be sort of more of a challenging feature to it, because that it will impact their lives and those of their loved ones and society.
Now, another thing about guilty pleas is that obviously the judge can give a sentence, even if it's kind of a joint position, above and beyond what the Crown may have said to you. How clear should you be about that? You know, you mentioned obviously putting this in writing, that the judge, and you certainly you mentioned this as well, but that the judge could give a sentence of their own volition. Uh, how clear and how thorough should you be with your client that that's a possibility? Have you seen at times where, you know, a joint position was sort of given, was ignored, and a more harsher penalty was given by the judge, and a client being upset about that? What could you do to sort of soften that possibility?
Yeah, so I mean, first of all, joint submissions are often very informed. You know, the Crown has their duties and are bound by certain ranges. So it's not like they'll throw a number out there that will be completely disregarded by a judge or risk having done so. And likewise with defense counsel. So we go off precedents and ensure that there are certain ranges that we try to fall in between with various different sentencing features that we have to take into consideration. Of course, fundamental to the defense would be personal characteristics of the client as well as others such as enunciation, deterrence, and whatnot. So having said all that, the case law does point towards judges giving deference to joint submissions to a great deal. However, they can jump the positions, and I've seen it happen. Very limited occasions, but it has happened where the judge does jump and goes harsher. But I've also seen it go jump and not personally, but I've seen it where the judge jumps and goes lower than the joint submission, which is quite odd, but it can happen, I guess. So I've heard of that happening as well. So I think just knowing that the two adversarial, sort of the two pieces, the Crown and the defense, are combining what they think is a just and fit sentence, and I think a judge will typically defer to it. And again, when it's not a joint submission, if the Crown wants, say, 30 days and the Crown asks for 15 days, again, the judge has any range to deem it right in the middle, or go towards more to the defense or the Crown, or even higher than what the Crown asks. So again, there's a lot of wiggle room there. But when it comes to joint positions, the reason why they're so favorable is because typically it should be satisfactory to a judge.
So thank you so much, Sia, for taking the time there and answering all these questions, and for all that very informed, informed guilty pleas there, keeping us informed. So if you have any final words of advice for my paralegal students, I know you've even taken one at least on as an intern for you, but any advice for kind of making the transition from being a paralegal student and wanting to get into criminal law? What can you offer them in terms of preparing for all that and being a successful advocate for their future clients?
Right. So make sure that you build good relationships with your clients. Always adhere to the rules of professional conduct, and make sure that everything's by the book, and that you're keeping up with the trends, and just building good relationships with your clients, I think, is the main thing here, and advocating fiercely for them, of course. And I think by doing that, you ensure that they trust you. You build good referral systems, and ultimately you will succeed, but also secure a good reputation within your field, and ensure that others, your colleagues, rely on you, depend on you, and you'll have success at doing what you do, whether it's in a firm or on your own. I think building on those features are quite important, and in order to be successful as a criminal defense lawyer or a paralegal.
Perfect. So all the best to you in your practice.
Thank
you once again for joining us for a second time here, and take care.
My pleasure. Thank you to everyone. Thank you.